with Judge Mr. Andrew Wheelhouse as President of the Court. The current matter before the Court is the case between Omani and Chatter as applicants against the State of Omeria as respondent. Each side has 45 minutes to present their case, and the first counsel for the applicants is requested to come forward.
Your Excellencies, Mr. President, may it please the Court. I am Angelo Manuel, first counsel for the applicant, together with Ms. Don Chua, our co-counsel, and Ms. Kathleen Pantry, our off-counsel. We respectfully request 22 minutes for our first two submissions. That the prosecution of Mr. Omani under both the No Hate Act of 2011 and the Anti-Terrorism and Extremism Law of 2013 violated his right to freedom of expression. Subsequently, we also request 21 minutes for my co-counsel submissions. The prosecution in both cases violated Mr. Omani's right to privacy, and the prosecutions in both cases of Chatter violated international principles on intermediary liability, privacy, and freedom of expression. We also reserve 2 minutes for rebuttal if necessary. If your Excellencies have no preliminary questions, I respectfully request leave from this Court to begin my submissions.
Thank you, Mr. Manuel. Would you just clarify exactly what points you will be dealing with?
I will be arguing, Your Excellencies, on the freedom of expression aspect of issues 1A and 2A.
Okay, so freedom of expression with regard to both Mr. Omani and Chatter.
Your Excellency, freedom of expression only for Mr. Omani.
Freedom of expression for Mr. Omani. Okay, please proceed.
Thank you, Your Excellency. Nothing embodies the freedom of expression better than the Internet, Your Excellencies. Through the Internet, each and every individual is granted a voice to discuss, critique, and question. And through it, Your Excellencies, we are able to dissuade and expose dangerous ideas such as racism, to scrutiny, and ultimately arrive at better ideas. It is the first submission of the applicant, Your Excellencies, that the prosecution of Mr. Omani for posts number 1 to 3 violated his right to freedom of expression. At the outset, Your Excellencies, the applicant would like to emphasize the unlawful application of the No Hate Act to posts number 1 and 2. We would like to direct this Court's attention to paragraph 14 of the facts. Under paragraph 14, Your Excellencies, it shows clearly that post number 1 was made in 2009 and post number 2 was made in 2010. The No Hate Act, Your Excellencies, was effective in 2011, 2 years after the posts. And we submit, Your Excellencies, that Mr. Omani was penalized for conduct which was not punishable at the time he made them. And consequently, the State of Omeria violated his rights under Article 15, Paragraph 1 of the ICCPR and Article 11, Paragraph 2 of the UDHR.
Is it quite that straightforward, Mr. Manuel? Surely you can regard the posting of items on a social media site as a continuing course of conduct, can you not? Same as if you kidnap someone and then partway through your course of conduct of kidnapping, an anti-kidnapping statute came into force.
Your Excellency, while we understand your concern, there has been no jurisprudence on the matter declaring hate speech to be a continuing offense. And consequently, Your Excellencies, in light of that, we must view it in the presumption of favor of the applicant in this case. Moreover, Your Excellencies, under this submission, we will offer 2 points. First, that Mr. Omani's speech was merely satire and not hate speech. And second, that the conviction under the No Hate Act was an impermissible restriction on Mr. Omani's right to freedom of expression.
Where some offensive words were kind of spoken, but the program was journalistic in essence. It wasn't even satire, which you're claiming in this case. So how, once again, post number 2 could be understood as satire? Because I don't see any way that it could.
Your Excellency, a good example is the American film Borat, wherein the Sacha Baron Cohen portrayed an exaggerated version of an anti-Hazan and repeatedly called for death to America in that particular film. And nevertheless, the viewers understood it to be mere satire, even though the literal import of the words was offensive or even a call to violence. Moreover, Your Excellencies, the important ruling in Jersey is paragraph 38, wherein An important consideration, Your Excellency, is the primary purpose of the speaker, whether it was to propagate racist views or ideas. And in this case, Your Excellencies, we submit that it was not the purpose of Mr. Omae.
Yeah, but Council, should we not look also at the effect on the audience? If you look at the response to person number 5, there was a reply by an alleged terrorist group. Doesn't it show that the effect of the speech is to some extent hate speech?
No, Your Excellency, would like to disagree as to the effect. And moreover, we must take note of the fact that just because someone names himself Night Watcher doesn't mean that he is automatically part of the
Case fall outside the margin of appreciation. I mean, the national court's already fully considered what appears to be your attempt to rely on the exemption for artistic expression, which I assume bringing arguments about satire to the table. You are trying to persuade us to overturn that finding. What was it about the way in which the national courts considered this matter that was deficient?
Your Excellency, first, the margin of appreciation for artistic expression must be narrow, given the fact that there must be an important consideration not only of the speech, but of the effect. And moreover, Your Excellencies, there is also a defect in the finding of the national courts precisely because they fail to consider the intent of Mr. Omae and the context wherein it was made. And that, as such, Your Excellencies, the findings of the national courts cannot be given weight by this court and must be overturned. We now move on to our second submission, that the prosecution of Mr. Omae for posts 4 to 6 under the anti-terrorism and extremism law violated his right to freedom of expression. Applicant submits that Mr. Omae's posts do not constitute an incitement of terrorism, as has been discussed and has been stated in the Council of Europe Convention on the Prevention of Terrorism, Article 1, Paragraph 5, as well as the Johannesburg Principles, Principle number 6. 3 important considerations are the intent of the speaker to incite acts of violence, the likelihood of violence occurring, and the direct causal connection between the speech and the violence. An applicant submits that all 3 are not present in this case, and as such, Mr. Omae's speech does not constitute an incitement of terrorism. First, as we have discussed, the intent of Mr. Omae was not to incite acts of violence against ethnic Grenadians. As we have stated, his purpose was merely to provoke a discussion through the use of exaggerated satire. And consequently, Your Excellencies, there was no intent on the part of Mr. Omae. And more importantly, Your Excellencies, Mr. Omae ensured that people would know that the account was a terror account, as has been revealed in paragraphs 13 and 14 of the commentary, Your Excellencies. The Vigilante Insider account routinely made use of jokes, poems, and gossip. And moreover, explicitly in paragraph 14, he made use of satirical jokes. And because of that, Your Excellencies, the Vigilante Insider account was clearly satirical. And explicitly in paragraph 13 of the facts, Your Excellency, it shows that the bio of the Vigilante Insider referred to him as a political poet telling the truth from the horrors of power.
Mr. President, Your Excellencies, good morning and may it please the Court. My name is Don Shua, and I'm the second counsel for the applicants Omae and Chapin. For the next 21 minutes, I will be discussing our last 2 submissions. That first, the prosecution of Omae under the No Hate Act and the anti-terrorism law is an arbitrary interference into the right to privacy. And second, the prosecution of Chapter under these same laws violate international principles on intermediary liability, freedom of expression, and right to privacy. If this Court has no preliminary questions, I would like to proceed to a discussion or arguments.
Please proceed, Ms. Troy.
Thank you, Mr. President. Your Excellencies, the right to privacy is not about having some place to hide. It's about taking charge of one's person. It's about having the choice on how to present oneself in public or in private. It's about human dignity. And the importance of the right to privacy is highlighted by the fact that it is widely recognized as a gateway to the enjoyment of other rights, specifically freedom of expression. And may only be restricted under the circumstances provided in Article 12 of the UDHR and Article 17 of the ICCPR, which both provide that no one shall be subjected to the unlawful and arbitrary interference with the right to privacy. Before we proceed, Your Excellencies, I would respectfully like to invite your attention to paragraph 17 of the facts, which contain the relevant facts to our submission on privacy. Without Omani's knowing, and without even giving him the chance to defend his right to privacy, Omani's email and IP addresses were obtained by the state pursuant to Section 6 of the Anti-Terrorism Law. And using the IP addresses, Your Excellencies, he was identified as the user behind the Vigilante Insider. And the next day, the state disclosed his identity to the media, and thereafter, he was prosecuted under the No-Hate Act and the Anti-Terrorism Law. We submit, Your Excellencies, that these acts of the government are an arbitrary interference with the right to privacy. The concept of arbitrariness is explained by the Human Rights Committee in paragraph 4 of its general comment number 16, to mean that an interference must first be reasonable, and second, must not run contrary to the provisions, aims, and objectives of the ICCPR. The concept of reasonableness, Your Excellencies, is explained by the Human Rights Committee in the case of Tunin versus Australia. In paragraph 8.3 thereof, it said that an interference must be necessary to the circumstances and proportionate to the end sought. We submit, Your Excellencies, that the order to disclose Omani's identity was unreasonable and ran contrary to the provisions, aims, and objectives of the ICCPR.
I take it, Ms. Chua, that you're binding yourself to Mr. Manuel's points about this obviously all being satire.
Yes, Your Excellency.
Yeah. If we don't agree, where does that leave your argument? What if we decide that, in fact, the national courts were absolutely right in deciding that Mr. Omani's posts were bona fide hate speech? Where does that leave your argument?
Your Excellencies, we submit that the prosecution of Mr. Omani must still be held as invalid because it violates the right to privacy, Your Excellencies. And we present 3 points. The first is that the order to disclose Omani's identity was neither necessary nor proportionate to the prevention of violence within Ameria. Second, Your Excellencies, the Section 6 of the Anti-Terrorism Law, which was the basis for the order, does not provide for procedural safeguards against abuse of the information obtained. And finally, Your Excellencies, the order does not recognize the right to due process of Omani. Turning now to our first point, Your Excellencies, we submit that the order was not necessary precisely because nowhere in the facts does it state that any of Omani's statements were directly or indirectly connected to any violent event within America. The order did not recognize the right to due process of Omani. Your Excellencies, in KU versus Finland, the European Court of Human Rights ruled that even during criminal investigations, a defendant must still be accorded his full due process rights, including his right to privacy and freedom of expression. Your Excellencies, the issue on the due process rights of anonymous speakers is yet nascent in the international environment, Your Excellencies, and we submit as guidelines for this court the ruling of the New Jersey Supreme Court in the case of Dendrite versus Doe, where it was required that before an anonymous speaker can be unmasked, the plaintiff must first take reasonable steps to notify the anonymous speaker that there was such an application. And we submit, Your Excellencies, that this is the best balance between the right to privacy and the interest of the state to prevent violence within Ameria. Your Excellencies, having established that the court order to disclose Omani's identity violated the right to privacy because first it was unreasonable, and second, it does not provide for procedural safeguards, and finally, that it does not respect the right to due process. I now move on to our last submission, that the prosecution of chatter violates international principles on the right to privacy, on intermediary liability, freedom of expression, and right to privacy. We present 3 points, Your Excellencies. The first is that chatter should not be held liable for the post of Omani. And second is that the prosecution of chatter negatively affects freedom of expression within Ameria. And finally, the same prosecution negatively affects the right to privacy within Ameria. Turning now to our first point, Your Excellencies, there are only 2 international instruments that deal with the issue of intermediary liability. And it is first the 2011 Declaration of the Special Rapporteurs of various international organizations, including the United Nations and the Organization of American States. Secondly, Your Excellencies, we present the 2015 Manila Principles on Intermediary Liability. Your Excellencies, we submit that this court take these two instruments as heavily persuasive guidelines on the issue of intermediary liability, precisely because these two instruments were the result of a comparative study of intermediary liability regimes, as well as legislation and jurisprudence on the matter. Your Excellencies, both instruments provide that no one shall be liable for speech on the internet which is not their own, except in two circumstances, Your Excellencies. First is if he has adopted such speech as his own, and second is if he refused to obey a court order to take it down. And Your Excellencies, nowhere in the facts does it say that Chatter adopted any of these posts as his own. And secondly, Your Excellencies, in paragraph 17 of the facts, after when Chatter received the court order saying that ordering it to take down post number 4 to 6, it immediately took it down.
Drawing the line at requiring a court order is pretty severe, isn't it? What if they just have sufficient notice that there is a problem with a particular post, and on that basis they should be required to take that post down? That's sufficient, isn't it?
Your Excellencies, we submit that in cases where the speech is not patently unlawful, a court order would be required in order for the intermediary to take it down. And this was the ruling of the European Court of Human Rights in the case of MTE versus Hungary.
But what about Delphi? That's a Grand Chamber decision, so it outranks your reference to MTE, which is only a section decision. The court gave longer and much more comprehensive consideration of all these issues in Delphi. Why shouldn't we just follow that case?
I understand you consider Your Excellencies. MTE also applied Delphi versus Estonia, Delphi AS versus Estonia. Moreover, Your Excellencies, Delphi AS versus Estonia does not apply to the present case because, Your Excellencies, paragraph 116 thereof provides that social media, the ruling therein does not apply to social media platforms that do not provide content of their own. And Your Excellencies, in paragraph 6 of the facts, Chatter does not provide content of their own.
Mr. President, Your Excellencies, my name is Obadia Ismail, appearing before the respondent. In my first 41 minutes, I will submit, and I pray that I reserve 4 minutes for rebuttal.
Yes, thank you, Counsel. I assume you're going to be dealing with, well, everything.
Yes.
Was there a particular structure that you wanted to follow?
Yes, please.
Yes.
Your Excellency, in my first submission in 41 minutes, I will show to this Honorable Court why the prosecution of Omani under the No-Hate Act does not violate these international principles. And then in my second submission, I will show to this Honorable Court why the prosecution of Chatter under these same international principles does not render the prosecution invalid because they do not violate these same international principles. Your Excellencies, I will go ahead and show this Honorable Court why the prosecution of Omani under the Omarian extremism and anti-terrorism law does not violate the same international principles as well as Chatter. Unless directed otherwise, I'll proceed, Your Excellency. Much obliged. Your Excellencies, my learned friends on behalf of the applicants raised a number of issues before the Honorable Court, and amongst them, they raised the issue in relation to retrospective application of the law. Your Excellencies, on the outcast of my submission, allow me to show, to state before this Honorable Court that the Omarian government does believe and uphold the principles in hindsight versus United Kingdom that the freedom of expression is the essential foundation in a democratic society. And we do believe and we do respect these principles. However, we do believe as well, just as stated in Article 29.2 of the Universal Declaration of Human Rights, as well as in Article 15.2 of the ICCPR, that the exceptions and circumstances under which these rights can be limited. Now, with relation to a retrospective application, Your Excellencies, we submit that much as the right ex post facto is a non-derogable right under Article 11 of the Universal Declaration of Human Rights, we believe that Article 15.2 of the CCPR lays down a rule upon which the states can rely on to prosecute an individual, much as there is no domestic law to that effect. And on this basis, it provides to the effect that nothing in this act shall prejudice the trial and punishment of any act that is criminal and recognized under the United Nations, by the United Nations Committee. Now, that being said, Your Excellencies, when you look at paragraph 14A of post 1 by Umani, it's clear that it's quite discriminative. And when you look at Article 4 of the Universal Declaration Against Discrimination, it provides to the effect that any post or any act that leads towards discrimination, be it on ethnic grounds, be it on color, be it on race, should be denounced by the states. It's upon this basis that we, the government, submit that regardless of the fact that this freedom, this right has to be enjoyed, and regardless of the fact that we had no domestic law, given the fact that the No Hate Act was enacted in 2009. However, Article 15.2 of the CCPR gives us the go-ahead to ensure that provided these are acts which promote and instigate violence that can bring about acts of terrorism amongst the citizens of America, and as a duty and fundamental obligation of the state to provide safety, to provide security for its citizens, the government had the duty to ensure. Now, when you look at that aspect, and when you look at paragraph 9 of the No Hate Act, mainly section A, it provides to the effect that anyone who disseminates to a white group an insulting or degrading statement is liable under this act. Now, however, Your Excellency, it's our submission that much as it may defeat a reasonable purpose to analyze it post by post in order to construe the liability of money, we pray to this Honorable Court to look at the post in an entirety and general perspective.
Yes, and on that note, sorry to interrupt, Counsel, but on that note, the applicants are very insistent that this is all a big mistake and it's all intended in jest, it's all satire, intended to further the cause of equality and religious and ethnic harmony. I assume you have something to say on that rather bold submission.
In relation to satire, Your Excellency, if I may direct your minds to the general comment number 11, mainly recommendation 8 of the Human Rights Committee on General Human Rights Committee. Your Excellency, this recommendation lays down a number of issues that needs to be proved in relation to hate speech. Much as my land friends are saying that this did not amount to hate speech, it was a satire expression. Your Excellency, this recommendation states that there has to be proof of the context of the expression needs to be put in place. The speaker has to be put in consideration. The intent, the content, the extent and magnitude of the expression, and above all, you have to consider that there will be a likelihood of the advocated action occurring. Your Excellency, when you look at the fact and when you look at the speaker, that we later on realized that it was Umani, much as he was hiding behind the veil of the vigilante insider. Your Excellencies, you will see that from the fact that he's hiding behind the vigilante insider shows the mens res, that is the ill intention. Now, when you take all that aside and you look at, if I may refer you to the paragraph 3, in relation to the person who responded to one of the posts, hearing you loud and clear. Your Excellency, when you look at all this context, it kind of shows that much as we need to prove all these grounds, and given the fact of the person who is posting this, given the followers that he has, and given the kind of state of affairs, when you look at paragraph 3, mainly line 4 of the hypothetical case, you see that currently in the borders of Marian and Brina, there are still acts of violence occurring. And therefore, for the government to risk such kind of posts, just because, probably because he's the Prime Minister, or probably because we want to protect his right of anonymity, is a different risk that, as far as the security of the country is concerned, needs to be upheld. Talking about anonymity, Your Excellency.
So you don't have a view, then, Counsel, on whether or not the whole thing is satire? Are you saying the question of satire is neither here nor there?
No, Your Excellency, we are submitting in relation to satire that this statement, these posts were not satire. In fact, they were hate speech. Why we say that is because when you look at the whole posts of Omani, it's quite discriminative based on ethnic grounds. And when you look at the capacity, as I stated earlier in relation to general comment number 11 and the recommendations 8, when you look at all those ingredients that you have to prove in order to establish and prove whether or not a person can be held liable for instigating and promoting violence amongst the people, you see that the person in question, Your Excellency, before this Honorable Court, Omani, had all that it takes to carry out these actions. It may not be direct, but at the end of the day, by the fact that we had responses from the public towards carrying out these efforts, and it should be noted.
Okay, Councillor, then to take the applicant's example again, say Borat. Are you familiar with Borat?